Hi, today I'm going to express my opinion about the reason behind the central government planning to decriminalize the check bounce law. Well, what kind of decision the central government might take in the coming future pertaining to this subject, I will not comment, because as an officer of the court and an officer of the judiciary, we are not at all bothered about the decisions of the government. We only analyze the law, we only apply the law. And therefore, if government is interested to scrap the check bounce law, it's fine with us, because we are not a party when the law was brought in 1988, 30 years ago, and we will not be a party when the law will be scrapped. But we are interested in the reasoning, because judiciary is always interested in the reasoning, because reason is the soul of justice. So why at the first instance this check bounce law was criminalized? We will understand that aspect and what happened in the course of 30 years. Then we will guess why government is planning to decriminalize the check bounce law. Now, there can be fundamentally either law can be a civil law or a criminal law. There cannot be a hybrid law like check bounce law, because check bounce law is a hybrid law. It is a civil law with a criminal flavor. Originally, it belongs to Negotiable Instruments Act. Now in 1988, because many checks were getting bounced and banking system is getting clogged, government want to penalize the check bounce law. So that government expected that there will be acceleration in the economy and declogging of the banking system. But in the past 30 years, I am of the understanding that more than half a dozen times check bounce law was amended. Why it was amended? Because it is a hybrid law. It is a civil law with a criminal flavor. So law can never be like that. Therefore, central government polluted the law, polluted the civil law by giving it a criminal flavor. Therefore, it failed. Therefore, it was misused. And it was amended more than half a dozen times. And still there are 35 or 40 lakhs. I could not disclose the actual figure, but there are a lot of cases pending in the court because of the faulty law. The law itself is at fault. Therefore, it failed. That is my understanding. Now, whether it will be criminalized or it will be decriminalized, it will not change my profession or my job. Because if it is decriminalized, it will become a civil law again. Now we are doing for a criminal law, tomorrow it will be for a civil law. What difference does it make to us? Therefore, I am not going to make any opinion on this. But I am of the opinion that criminalization of the check bounce law failed miserably in 30 years. In spite of amending it many number of times, it was the most misused law. The accused was always in a precarious situation while issuing the check, and the complainant always took advantage of the law. And today, Supreme Court judgments and everything are in favor of the complainant, not in favor of the accused. And the fundamental reason is it is a polluted and a hybrid law, civil law with a criminal flavor. It is simply a recovery case with a criminal flavor. It hit the fundamentals of law, therefore it failed. And there was a lot of, because it was criminalized, government was also having a lot of burden. Judiciary was having a lot of burden. Special magistrates were appointed, special courts were appointed. In spite of that, check bounce law began to increase. The cases began to increase. And ultimately, government is planning that proposal, and I don't know what kind of decision government is going to take. I'm not in favor of criminalization, or I'm not in favor of decriminalization. We are neutral on behalf of the judiciary. I'm neutral.